Good afternoon and welcome to the law. This is your legal light. It is your help law. Today we dive into a topic that touches the heart of marriage, justice and gender equality. Spousal maintenance in Ghanaian law. We ask the question, can a husband ask the court to be maintained by his wife? The judge who provoked that question is right here in the studio with us. Justice Alexander Osei-Tutu. He is a justice of the Court of Appeal. He's an author. And we also are joined by lawyer Kuku Wilson-Jones, legal practitioner, as we unpack the legal, cultural, and constitutional dimensions of maintenance before and after the Matrimonial Causes Act 1971. We break it all down. Ghana's Matrimonial Causes Act, gender roles, and the future of marital responsibility. We'll be right back. Right. Welcome back. This is your legal light. It is your helpful law. This is the law. And look on your screens right away. I'm showing you a news card. It's a news card I'm sure you have become very familiar with in the course of this week. Under Ghanaian law, needy husbands can go to court if wives refuse to take care of them. Court of Appeal judge reveals. That judge is right here to demystify all the controversy that have surrounded this particular, statement. My Lord, good afternoon. Thank you very much for making time to join us once again.
Thank you, Samson.
And good afternoon to my very good friend, Kuku Wilson-Jones. Thanks for making time to join us.
Thank you, my brother.
Right. So, first of all, I'd like us to get back to that particular postulation. Can a husband legally apply to the court for maintenance, from his wife under the Ghanaian law? Yes, my Lord.
Thank you. Yes. If you look at Section 16 of the Matrimonial Causes Act, I have it here and I would want to read.
Okay.
It's headed, neglect to maintain spouse or child. 1. Either party to a marriage may petition the court for an order for maintenance on the ground that the other party to the marriage has willfully neglected to provide or to make a proper contribution towards reasonable maintenance for the petitioner or a child of the household. In the past, it used to be that it was the husband's responsibility, but now the statute we all know overrides customary law. It says either party, and the heading is neglect to maintain spouse. So either way.
Gender neutral.
It's gender neutral, thank you.
So when you say in the past, that's before 1971.
Exactly.
What was the law then?
Thank you.
Hold on quickly. Now, Justice of the Court of Appeal, Berima Yao Kodie Opong, I hosted him here 2 years ago on this platform, and he spoke about distribution of marital property. And he said a husband has no business whatsoever seeking to have a share of what belongs to the wife. Let's listen to him. Now, Article 22 of the 1992 Constitution says property rights of spouses. A person shall not be deprived of a reasonable provision out of the estate of a spouse, whether or not the spouse died having made a will. Parliament shall, as soon as practicable, after the coming into force of this Constitution, enact legislation regulating the property rights of spouses. We have tried, we have not been able to do that. So it is said that the property rights, they smuggled some of it into the Land Act. Clause 3, with a view to achieving the full realization of the rights referred to in Clause 2 of this article, A, spouses shall have equal access to property jointly acquired during marriage. And this is the one that is prominently known. Spouses shall have equal access to property jointly acquired during marriage. B. Assets which are jointly acquired during marriage shall be distributed equitably between the spouses upon the dissolution of the marriage. Okay, so pardon me, this is not what I was asking for, but I was reading this whilst I was interviewing him, but he made that point clearly that when it comes to distribution of property, the tradition, custom over the years, and even still persistent, is that it's the man's responsibility to take care of the home, and the woman, it's not her business whatsoever. She may only do that out of her own generosity. So, my Lord, back to the question.
Thank you. I think we all heard it. He said the spouse. We didn't hear anything like the husband's responsibility or the wife's, the spouse. So for some few decades, the law has shifted from putting the responsibility on only the man. And this is the Constitution. Article 22 is there, black and white, the spouse. Yes, in the past, Olenu told us how customary law recognizes or dealt with the husband and wife. And for the lawyers, they may want to refer to the case of Kwate versus Mate. Kwate versus Mate, 1959 Ghana Law Report, is reported at page 377. This is what Olenu said, and I would want to read. Again, by customary law, it is a domestic responsibility of a man's wife and children to assist him in the carrying out of the duties of his station in life, e.g., farming or business. The proceeds of this joint effort of a man and his wife and our children and any property which the man acquires with such proceeds are by customary law the individual property of the man. It is not the joint property of the man and the wife and or the children. The right of the wife and the children is a right to maintenance and support from the husband and father. So in the past, if a woman helps the man, let's say the man is a cocoa farmer, and the woman helps him together with the children, the law is saying that, or the law used to be that, whatever came out of the cocoa farm, if the man decided to use the proceeds to put up a building, the woman had no share in it. It was solely for the man. The man's duty was to maintain the wife, maintenance. That was the man's responsibility and nothing more. But the law has now shifted, changed, and the law is now saying that we all know in 1985, PNDC law 111 stepped in and said we are shifting it from the customary law position where it was the man's, it was only the man who could benefit from property acquired. Now, if the law, the simple logic is that if, okay, let me bring this common law aspect of the, at common law too, there was something called coverture. It used to be that if a woman marries, she lost her identity.
She, even as a human being, was a property of the man.
Yes, was the property of the man. And she was not entitled to work. If she worked, she could only work where the husband had consented. And at the end of the period, or at the end of the month, whatever wages or salaries were paid to the man's accounts. So the man used some of the proceeds to maintain the woman. But now the law has changed to the extent that if a woman works and at the end of the day, whatever money does not go to the husband.
That's right.
It goes to the man. So the basis upon which men maintain their wives is now defeated.
Right. And this is a subject you have treated in your second book, Contemporary Legal Issues. So, Kuku, I've seen that you are... Yeah, oh, you have a coffee here.
I got it here. I got it here.
You have a coffee here.
Yeah,
and you have spread in front of you several other legislations and is it judicial decisions?
Yes.
Is it really the case that the law now treats both spouses equally when it comes to maintenance obligations?
Thank you. Respectfully, no. I mean, what we have in the books is not what we practice.
You said respectfully, no?
No.
Okay, so you are familiar with him. He will generate the controversy, but he will resolve it.
No, the issue is this, that you see, you can have laws and still not obey what the law stipulates. You know?
Okay.
What I mean is that we have used the gender-neutral thing, spouse. But with all due respect, I wouldn't mention the judge, but I've been before a judge, a lady, where we were trying to get something for a man whose wife had died. And so we tried to claim something from the Social Security angle. And the judge said, young man, have you seen a man inheriting a woman before? Surely later she changed her mind, but that is the perception we have. And the perception is captured beautifully.
Is it a perception or is cultural?
No, cultural.
It's part of us.
It's part of us. Look, my Lord has done a beautiful thing in this book. It's like my little Bible, contemporary evolving issues in civil procedure. Everything is here by curvature.
Right.
Now, he has said the good things that women should really get if they would want curvature put aside. But our women are people we can't predict. They want to have their cake and eat it. Oh, sure. Let me just read something.
They want to eat their cake and have it.
Yeah. They want to eat a cake. Look, they want to have both ways. My Lord has brought something. Let me just read it for curvature.
Okay.
Because he has brought the issue that curvature really has taken every identity from the woman. So in this beautiful book that he wrote, let me see what he says. He said the woes of women in society could largely be attributed to curvature, which was a legal doctrine that ensured that upon marriage, the husband's legal identity shielded that of the wife. So now the woman is not independent. We will not bore readers with the details. Now he brought one issue up, and that is the lingering thing about curvature, that thing called Mrs. MRS. And finally, when I was in GIG in 92, one of our lecturers came out that MRS meant man's registered servant. And so the women should be too happy in having it. With all due respect, that was a funny aspect of it. Now, what my law states is this. Curvature, or this Mrs., should remind the women of how far they have come. That for over 400 years, they were being controlled by a man. Now, he has revealed that in the United States and even in England, they have tried to go let all these things go.
It's not really the case that they were being controlled, but they were happy and they coveted it to be under the man, lose their identity under the man. And even if they worked, their salary or their pay went to the man.
Yes, but that's what I'm saying. And not that the law has given them the liberty. They don't want it. They still want to keep this title, Mrs., and still go on with the things that they come to.
Oh, really?
See, yes, really. Haven't you seen the beautiful, what do you call it, the divorce between those two politicians? I wouldn't want to mention their name, but one works in the president's, office. She's gone back to her real name. But until the divorce, how dare you call her without putting the prefix Mrs.? You see, that is how debatable the issue is. But as my Lord said, surely there is nothing that says that a woman who is now relieved of that curvature and is working should still be dependent on the man. Surely a woman of these days are not like what we used to have in the past. They are working, and sometimes most of them earn more money than the men.
Most of them?
Oh, they do, yes. Most of them earn money more than the men. But when it comes to either a separation or divorce, they still want to have that which belongs to what? The man. There have been cases my Lord had listed, we have read that a woman is not really given the authority to own property by the PNC Law 111.
That's right.
So whilst married to the man, she can. Now, I have seen cases in which I have been in part of the divorce where the woman wants the matrimonial home. She had her own building, but she had hidden it by putting the name in the child of a child. You see, until we had to find out how the child came by the money to build. So our society is that the women still do not want to be responsible. I don't have any apology for them. They always want to have theirs without our participation, but they want to have ours too. So I believe that the law is there. We would pray that our judges would try to be a little bit tough when they come, and they come with tears that they would want to have ours. We should also have theirs.
As I understand, my Lord, your view is that, yes, your view to my question is that, yes, the law does treat both spouses equally when it comes to maintenance obligation, because as you read Section 6 of the Matrimonial Causes Act 367, 1971, it uses spouses, which makes it gender neutral. So what I come to now is, why did the law evolve to allow wives to maintain husbands? What social or legal realities prompted this shift? Because you have given us a bit of the history.
Before I go on to that, I beg to disagree with your point that the women don't want to be responsible. Some women are doing very well. We can say some women, and for those who haven't yet started, we entreat them to also. In fact, the law is funny. Right goes with responsibility.
Right.
And so we cannot expect to get more rights and check their responsibility.
Okay.
Immediately, we ask for women empowerment. Let me read the Economic and Social Council of the United Nations. It's in my book, page 422.
Yes, my Lord.
This is what the United Nations said. Believing that the legal personality of husband and wife and the sharing of spouses of the authority, prerogatives, and responsibilities involved in marriage. Responsibilities. So the United Nations, that is promoting women empowerment.
Right.
It's talking about responsibilities involved in marriage. So in as much as now we are drifting away from the customary law position, where if a woman helps the husband to acquire any property, it belongs to the man, and now the woman can acquire her own property, then it presupposes that what the man was doing, the maintenance that the man had to do, need to be revisited. So you see, UN is moving towards a certain direction, trying to bring women. The Bible said the two shall become one.
Right.
And once we come together, it is said, Benkum Jari Nifa, then Nifa Jari Benkum. So I think this is the notion that influenced the lawmakers to use gender neutral. And we've come a long way. In fact, I would say Ghana was even ahead. Before Beijing in 1995. This act we are talking about was enacted in 1971. And we had used a gender neutral word, spouses.
Yeah.
The 1992 Constitution, that was also before the Beijing Conference. Spouses. PNDC law 111. In the past, like I said, the woman will help the husband, the proceeds he uses to acquire property, and the woman had no interest in that property. The man's duty was to maintain. Now the law says that, and the man at the end of the day would pass the property on to his family. Now the law is saying that the property is not supposed to go to the family. It should go to the other spouse. So it's now more or less a partnership. So that brings into focus or into perspective the need to consider the responsibilities that were entrusted, and woman, come and help me, and I maintain you. But now you help me, whatever we get is for the two of us.
So even if you look at Article 22, when it comes to dissolution, where it talks about 50-50 sharing of property, it is property that was jointly acquired during the subsistence of the marriage.
Yes.
So if it was jointly acquired, then it means it was contribution from both sides.
Yes.
Now, that takes away the traditional, perspective that you have brought on earlier, where the woman will contribute but will not be entitled
Yes.
to any portion of the property.
Yes.
So would you say that the change we have come to now of gender equality in the question of maintenance, how much of it is informed by the Constitution?
Yes, I want us to look at it in two ways. Yes, the Constitution uses the word spousals when it comes to property. You go to, I think, Article 17 or 18. It talks about equality.
The right, equality.
Equality. And the Constitution permits individuals, we all know, we the lawyers know, friend versus friend, where the Supreme Court held that the mere fact that we've come together does not mean that you cannot acquire your individual. We have the right to own property.
Right.
In the same vein, the woman in the marriage also has the right to own property. So I don't think it would be fair for you to say that now the husband should maintain me, I'm working, I will not contribute in terms of maintenance to the marriage, and I use my property, my money to acquire property. I don't think. So you look at the whole rights that have been conferred on women, as well as their responsibility. That's why I started with the traditional, the customary principle in the past, that the husband should maintain you, and you support him. Whatever property, you are not, the woman is not counted.
We'll advance the subject of maintenance, and you'll explain in detail what maintenance is.
Yeah.
But Kuku, coming to a point where you may have hit the nail right on its head. In 2007, as far as property distribution is concerned, in Mensa versus Mensa, the Supreme Court brought a novel position, which many judges now use. That was to the effect that property acquired during the marriage should be shared equitably when there is a dissolution, even if the spouse did not make a direct financial contribution.
Yeah, I mean, it's fine. You know, I have to correct you. I think there was a slip when you were speaking. There's never been mentioned anywhere that there's something 50-50. You see, because this equality thing is a mirage.
Article 22 is 50-50.
No, but look, what do I mean?
It says equal.
Yeah, listen, when you read that, no, let's read the Article 22 of the Constitution. Because when you come, Article 22(3), right? You have 3A. It says spouses shall have equal access to property jointly acquired during the marriage. So
correct.
That is equal access. Then you come to 3B. That says assets which are jointly acquired during the marriage shall be distributed equitably. Equitable is not equal. So equitable is an elastic word. That's an adverb. If you went into it, then you can say because of this, because of that, surely the other spouse has a say. So it is never 50-50. No, it is never 50-50. The issue is that equitable is an elastic thing.
Correct.
So you will get Judge A to really interpret equity to be
how
something.
much you contributed is what you get.
That is it.
You get according to the proportion of your contribution.
That is it.
So 50-50 is a wrong.
It's wrong.
You know,
it's totally wrong.
Description. Correct.
It is equitable. So my Lord knows it. We all know they are the law is in their bosom.
Right.
The fact is that
now to the question I asked.
Yes.
That post Mensa in 2007, the Supreme Court's posturing, which is now being followed prominently, is that you don't have to have made a contribution.
Well, it's fine, but
initially the woman had to make contribution. Then it moved to significant contribution.
Yeah.
And now they say, forget contribution.
No, I agree with them to some extent. You know, really, when you argue or you want to argue with a woman, they tell you one specific thing, and that is to do with the pregnancy. That surely to keep a baby for 9 months, they are not thinking of something tactile. They are saying that spiritually, I kept a baby, I could have died, and most women have died during childbirth. So they are due for something. It's to do with the quantum. And then the few things they do. But let's put this thing in perspective. There is a lawyer by name Quran, I think it's in the Brown Afro region. Daniel Quran. He's here to publish something he has written beautifully. And when you read it, it tells you the Supreme Court is confused, with all due respect. Because when you take the Supreme Court law reports on property distribution, they are not ad idem. They are a group that really tilt towards the females, and there are groups that tilt toward the males. So I'm praying that maybe if he publishes that beautiful thing, the Supreme Court judges would have to find a way to come to a consensus. Surely there is a confusion, and the title is the confusion that the Supreme Court has brought to property rights. And I believe, I concede that it is true. There is no clear thing marked from the Supreme Court that tells us how to distribute property either during or after divorce.
Okay, there are many who disagree with that.
Well, they should.
But my lord, so first, I want us to look at the scope of applicability of the provision you read, section 6 of the, is it 16? 16 of the Matrimonial Causes Act a while ago. Of course, I'll be projecting sections 19 and 20 as well of those provisions. But first of all, what is maintenance in law?
All right. To answer this question, I would want to take you to section 41.
Okay.
43 rather.
Okay.
Of the Matrimonial Causes Act. Maintenance comes under financial provision.
Right.
Financial provision is defined there. Financial provision means maintenance and any other forms of financial support provided by one spouse to the other or to a child of the household. So financial provision encompasses maintenance. And when we talk about maintenance, it's a broad concept. Even housing, accommodating the other spouse is a form of maintenance. Taking care of my wife is the one who buys my most of the things I wear. So she maintains me. Yes. So it's a form of maintenance. Right. So maintenance is not only about money. Maintenance can be in the form of money. It can be accommodation. It can be in the form of any assistance that you give to the husband in the eyes of the law can be deemed to or be described as maintenance. Right.
So what's the scope of applicability as we speak about the maintenance before we now, as it were, firm it up that it is both ways and not always the case that it is the man who must maintain the woman? So is the right to claim maintenance limited to, as in ordinance or civil marriages, or it applies to customary marriages, Islamic marriages as well?
Okay, thank you. This Matrimonial Causes Act, I would want to read section 41.
Okay.
Section 41 of the 41.1 provides, this act shall apply to all monogamous marriages. And in Ghana, there are 3 types of marriages. And it's only the marriage under the ordinance, which is monogamous.
Okay.
But you go to 2, it reads, on application by a party to a marriage other than a monogamous marriage, the court shall apply the provisions of this act to that marriage, and in so doing, subject to the requirements of justice, equity, and good conscience, blah, blah, it goes on. So I would say that it applies primarily to the Matrimonial Causes Act and to all other marriages, including customary marriage. But the law says that on an application by a party, so if you married under the Mohammedan law or marriage, or your marriage is a customary marriage, before you start the process, you need to file an application in court. We call it seeking leave of the court to be able to bring your petition. So in effect, we will say the act applies to all the marriages.
Okay.
First with the ordinance, and then the others you apply, and when leave is granted, you bring the petition.
Thank you very much. You're still here on the law. This is your legal light. It is your help law. And we are We are very happy to have my Lord Osei and also lawyer Kuku Wilson-Jones join us to look at the matter of maintenance, whether or not a man can be entitled in law to seek maintenance from the wife. How does the court determine maintenance in marriages governed by the customary law where traditional gender roles differ?
Okay.
You just said something to that effect.
Yes.
But does the law not recognize that in our tradition,
so this, I would want to read section 16.2 of the Matrimonial Causes Act. Yes, 16.1 says that either party may apply. But before the man applies, 16.2 says something. I'm reading. A wife shall not be deemed to have willfully neglected her husband unless the court is satisfied that. So here is a wife, not a spouse. A wife shall not be deemed to have been willfully neglected her husband unless the court is satisfied that in all the circumstances it is reasonable to expect the wife to provide or contribute towards maintenance for the husband. And for the purposes of so satisfying itself, the court shall consider an impairment of the husband's earning capacity.
An impairment
of
the husband's earning capacity.
Yes. In the past, he was doing it so well, but something happened.
He might have lost the job.
Yes, might have lost the job.
Have had an injury.
Thank you.
An accident. Okay.
And it was whether through age. So this man take care of you in his ripe age. Now he's 80 years. You, the woman, you are 60. Younger. You go and come every day. And the man is not working, and you still expect the man to maintain you. When you go and come every day, and that is an age, illness, and it's to a situation like that. There was an instance where the man, the husband, about 78 years, fell sick, was hospitalized for about 3 months. And anytime the woman goes to the hospital, the woman was stronger and was working. She still expected the husband to provide the transport and the chop money.
While he was on bed?
While she was saying, yes. And you, the woman, you go and come every day. So the law is saying that whether through age, illness, disability, something happened and the man became disabled.
Okay.
Or otherwise. And B, the resources of the husband. The wife earns about 5 or 10 times what the husband takes. It will not be fair to expect the husband to maintain, to bear all the responsibilities. And C, the earning capacity and the resources of the wife. The earning capacity and the resources of the wife. And D, any other circumstances relating to the financial position of the parties. So when it comes to maintenance, we look at the parties, their respective strength and all that, before we come to a conclusion that, no, in this circumstance, it is rather the wife who should maintain the husband or otherwise.
You have just preempted my question. I was going to ask Kuku. I was going to ask Kuku. But in practical terms, if the wife is well-to-do or has the capacity to perform these obligations to the husband who is needy, and she's not doing it, how can that needy husband get that support? Yes, my lord.
Yes, that is why, in fact, this law has been there for more than 50 years. And how many Ghanaians are aware of this law? Because we don't know the law. So we are educating Ghanaians that in a situation like that, it is not all lost. There are many men who have died because they got to a point, no support was coming, and they left themselves to fate and death too.
Hold on, before you tell us how you can actually access this, Kuku, is it really the case that men don't know this law, and that's why they are not using it? Because women have used it very much. Particularly when there is a child between them and there is no marriage or something of the sort, and and so on, or there's marriage and there's some separation, women have used this to ensure that the man is working every month, they are remitting, they are paying for they are paying the rent, they are responsible for the school fees and all that the children need. Now, is it the case that men, or we don't know about this law, or it is the case that men feel embarrassed or emasculated by seeking maintenance because it's a stigma?
Well, it could, culturally, as my Lord has even expressed in the book, we always think men are at the forefront. But things have changed. No, for over 50 years now, I can tell you now, how many times in the past 20 years, we have the ratio of a female judge to a male judge used to be 1 to about 10. Now, most of the judges are women.
Correct.
And they are assertive. And I have read an article which is beautiful. Really, I didn't think, but the person has one thing to say. He said when women become more successful, they are reluctant to marry, because they would want to have men of their own range. Surely, you wouldn't have a medical doctor or a very really prominent lawyer to marry even a taxi driver. It could happen because to women, love is not the issue. Mm-hmm. It's more to do with your social standard. Now, what the article said was that as women progress up and they become sophisticated, they look for men who also are sophisticated. And most men like that are already married. And what the argument was that as these women really show up, they tend to really love men who may be already be in positions already, and that leads to divorce. Now, I couldn't just think of the angle, but it's beautiful. The issue is this, that culturally, we thought women, or we still think women are weak. Women are not weaker. Look, they are stronger than us.
Okay.
And if you go, and I can tell you one thing, apart from being physically, women are by nature very smart.
All right.
I mean, the first temptation was by a woman. I mean, she conned, Adam. Women are smarter than men. That is why we've kept them under for a long time, and now they are certain. Okay. As for me, as my Lord has said, let's face the facts. Most people are not aware of this very thing. But I can tell you, if I fall in that category, I would go to court. No, I'll let my wife take care of me.
The question is, how many men will do that, knowing the cultural sensitivities, and they will see this as a stigma. But I'm telling
you, I would do it. There are not many men there who would do when the time is ripe.
Okay.
Surely, when the time is ripe, we would go and then ask them to play their role better than they are doing now.
Okay, so my Lord, I'm coming back to that question, which is practical and important. But let's hear Barima Yao Kodie Opong when I spoke to him 2 years ago about these two roles, particularly upon dissolution of the marriage and how property should be shared.
I discussed for a man to just stand in the presence of his in-laws and say that, yes, my wife is diseased, my wife is dead. Don't you know that under Article 22 or PNDC Law 111 or even during divorce, Matrimonial Causes Act, Article 22, I have a right to a reasonable share in the estate of my wife when it's about death, or I have a right to equal share or as a quantum that is determinable of the property of my wife. I want someone to just tell me, how many communities in this country, if at all, can this be tolerated? So, because the point really is that, and I said that from the days of Adam, God assigned responsibilities. That you, the man, should sweat, till the land, and have food. And after you have also gone to bring somebody else's daughter to your house, you feed that person and the children. It is for the woman to also carry the baby for 9 months or more if she's not lucky. And she will go through travail until she gives birth. These are distinct responsibilities God gave to us. And that is why it is not a woman that should go to another person's wife to marry a man. At least the dominant position is the opposite. But the idea that now people go to other people's house, take their daughter, and you now enter into a joint venture with her. Use your money to buy food, or use her chop money. I will use mine to build a house. And when there is dispute, you say, show me your contribution. In actual fact, under custom, the same. That is why even upon the death of a man, there is responsibility imposed on the members of that man's family to continue to provide for the wife and children in terms of their maintenance and all the necessaries of life. There is no such responsibility on a woman that when your husband dies, you or the customary successor of yours will then now take care of the man. So in the face of this, I'm saying that any law that has recently been crafted, and I didn't know that now even the understanding is that it was actually done for men substantially. Because we are the ones that traditionally we cannot be entitled to property of a woman, exclusively drafted for men. But it favors the men even more than the women. As I said, traditionally, a woman has always been entitled to part of the estate of the husband. Traditionally, during divorce, even if it's the woman who is divorcing, you say sumno. It is rather the man who will be asked generally to at least provide some compensation.
Sumno, alimony.
Sumno, alimony, yes. Provide some compensation for the woman. You understand? So that has always been the case. And I'm saying that if we go back to first principles from the days of Adam up to customary law, up to the areas where we were still struggling for this situation, if we just concentrate on the fact that it is that is what some people misunderstood Oleinu in the Courtier and Mate case. It is the responsibility of a man to provide for the necessaries of life, maintenance for his wife and children. There is no corresponding duty on a woman. If the woman decides to do so, I'm saying that it is just by way of generosity and her own sense of magnanimity. And this is the reason why, in my view, and I've asked, Parliament is not even able to comply with this mandatory provision of the Constitution. At least that is what, and this law, this bill, was drafted as far back, I understand, as 2008.
Right. So the point where he concludes is that in Article 22 of the 1992 Constitution, which came into effect in 1993, it was required that immediately after the Constitution comes into effect, there should be a law for spousal property, how spousal property should be dealt with. Up to date, we don't have that law. That is a problem. And he's saying we may not muster the courage to do it. My Lord, having heard everything that he says, does what he says, negate sections 16 onwards, as you have read to us?
That
there's no corresponding obligation on a woman to maintain.
Yes, he referred to tradition.
That's right.
Customary.
That's right.
But Article 22.
He's a chief. Yeah.
Yes, Article 22 of the Constitution talks about use the gender neutral with spouses. And if you go to Article 11.1 of the Constitution, we have the laws of Ghana listed there, which includes customary law.
Correct. Yeah.
But customary law, the Constitution provides that any law inconsistent with the Constitution is null and void. So if there was a custom like that, and the Constitution is saying this, I do not see how the tradition can override the Constitution.
Great.
Secondly, something, even statute. In the past, in Akan communities, what Oleinu said, if a man acquired property, the wife had no benefit. It went to the family. 1985, when PNDC law 111 was enacted, it changed the dynamics.
That's right.
Statute is speaking. How can you bring customary law? And now so we must all help the law to work.
Okay.
Yes, it's clear. And he talk about custom. They say where there's divorce, they say I want to read section 19 of the Matrimonial Causes Act.
So we project section 19 as my Lord is reading it. Yes, my Lord, go ahead.
Financial provision for spouse, not for the wife, but for spouse.
Right.
The court may, whenever it thinks just and equitable, award maintenance pending suit or financial provision to either party to the marriage.
Yeah.
But an order for maintenance pending. So either party to the marriage can benefit. So it's not only Oba Oba. Under the law, when your husband is, there's divorce, and your wife is well-to-do, and you look at all the facts, you can go to court for the court to make an order of maintenance so that your wife pushes you. You get something. And section 20 even says that if the court may, I'm reading, the court may order either party to the marriage to pay to the other party a sum of money or convey to the other party movable or immovable property.
This is while they are attempting the divorce, but the divorce is not done yet, or dissolution of the marriage, but it's not over yet. Maybe it can take 3 years or 4 years, but pending the dissolution of the marriage, the law in sections 19 and 20 is saying that the court can make an order that either party should maintain the other. And you have said earlier that the determinant is the economic status of either of the spouse.
And after the marriage has been divorced, 21 says, when a decree of divorce or nullity is granted, if the court is satisfied that either party to the marriage holds title to movable or immovable property, part or all of which rightly belongs to the other. So if your wife has a house, you don't have anything and the divorce, the court can make an order for your wife to give you some of the property.
Right.
Yes.
So if I were a lazy man, will the maintenance apply? Will the court be, interested? Will it be sympathetic to me to want to give me something as a lazy man?
That if you look at the law carefully, it says the court may order either party. The court looks at all the circumstances. The latter part that the court thinks just and equitable.
Okay.
So if the man is forcing and he's not getting the work, but where the person is lazy, a court can say, "Oh, you dear, you are not, you have not made any effort. You don't deserve to be helped," and it goes either way. It goes either way.
Interesting. You're still here on The Law. This is your Legal Light. It is your Help Law. And my guest, His Lordship Justice Alexander Osei-Tutu, and also lawyer Kuku Wilson Jones. We were hoping to open the phone line so that you can join us, but it doesn't look possible now. A couple of messages. Jifa says that today's show, dear, 1 hour is not enough. Fred says that men are usually shy of taking such steps to apply for maintenance. Remember the views Justice Opon shared in his paper at the conference in Cape Coast, that's 2 years ago. I'm sure a man who applies for maintenance from the wife would be seen as Kotobonku. Yeah. I have one such case I am conducting, and that's the impression I have of the man, unfortunately. That's the unfortunate part. My Lord, I asked him the question earlier, but he was reluctant to admit. Don't men feel there's a certain stigma asking that my wife should maintain me because I don't have money, I don't have a situation, I need all of these things?
We are coming from somewhere.
Right.
So we cannot discountenance or we cannot overlook our background.
Right.
But I believe with education, like some of what we are doing now, the men, after knowing their rights, would be able to, where the circumstance, many men have died because they didn't know their right, and their wives could have supported them. So it all borders on education. Yes.
What would you say? Someone says, unfortunately, the reality is that female judges are the protectors of patriarchy and they hurt their fellow women even more in divorce cases?
No, my Lord wants to be neutral.
I should be asking the lawyer, not you.
Yeah, my Lord wants to be neutral.
And let me step in. When you said the Supreme Court has been confused, I think it was too harsh a word. But the Supreme Court, maybe sometimes you may talk about inconsistencies, but they are not confused.
My Lord, I said that there is a confusion.
So before we go now, the question I asked, practically, I'm a man whose circumstances have changed by old age, by illness, by whatever the law speaks about, disability, that has occasioned my inability to take care of myself. How do I get my wife to do it if she's not doing it?
Being a Christian, I would say you explore. If you attend church, you can go to your pastor, you go to the elders in the community. You start from there. I'm not saying people should rush to court, but it's where all these domestic efforts have failed that the law is there. You go to court and you petition, you file the petition. If it is, I earlier indicated that if it's customary marriage, then you need to go to the court and seek the leave of the court to allow you to bring the petition. But if it is not customary marriage, it's ordinance, straight away, unless the marriage was contracted under 2 years. If the marriage was contracted under the ordinance under 2 years, the law still enjoins you to seek the leave of the court. Otherwise, there should be no impediment in your way in assessing.
Do I get the impression that you are talking about this application when you are seeking a divorce or a dissolution of the marriage?
No. If you look at the provisions of the law, where there's no petition pending, you can still go. And where there's a petition pending.
So in that case, you go by an application to the court.
Yes.
It is when you want to dissolve the marriage that you go by a petition.
Exactly.
Right. Interesting. Yes, quickly.
I want to just bring something to, as my law says, it's education, but I have a case here that is interesting. Gamble versus Gamble, and that is 1963 One Ghana Law Report. And let me just tell you what they're holding. One, when considering variations of alimony, and alimony is part of maintenance.
Yes, that's after divorce.
Yeah. The principle to be applied is how much money does the husband get every month from which he can maintain himself and his wife. Deductions for income tax and for compulsory savings, blah, blah, blah. Then it comes to the second one. The court will not look with sympathy upon a wife who makes no effort to secure employment, but is content to subsist on an award of alimony. Now, it's part of it, but I'm only telling you time will not, because I prepared for an angle which would help in educating. Maybe, God willing, we'll get a second chance. Right. The issue is this, that from today onwards, I think everybody must admit the law is so huge that one person may not know everything.
That's right.
So we would continue, and I think that the women would forgive us this time. They will take more responsibilities. My Lord, don't you agree with me?
Thank you. Thank you. Thank you so very much. My guests have been Justice Alexander Oseitu, to Justice of the Court of Appeal. Previously, he was a justice here in Ghana and in the Gambia as well. He is the author of a number of books, including the one that Fifi is using now, which some of us we also use very, very well. Okay, my Lord brought his own copy here.
Also brought
Fifi Kuku Wilson Jones is also a lawyer. Today's discussion reminds us that marriage is not just tradition. It's law, equity, and a lot more. Have a good afternoon. This has been The Law. It's your legal light. It is your help law. Maintenance is not a one-way affair. Equity and equality do matter.